All right. Well, good afternoon, everyone. Thanks so much for joining us. My name is Ryan Payton. I'm the director of the Colorado Attorney Mentoring Program, and glad you're here for our conversation today on the business of law. I wanted to have this webinar this year because this is a common question we get from attorneys across the spectrum is, how does this even work? How do law firms make money? What is my role in that machine? And how can I be of the most service my to my organization and to my colleagues. And so I'm so glad to have this conversation here today. A couple of housekeeping things before we get underway. We are in webinar mode, which means that we cannot see or hear you. So if you're having any technical difficulties, the best thing to do is get out of Zoom and get back in, and usually that will fix it. If for some reason there's something going on our side, we'll end the Zoom and restart it as well, but hopefully that won't be the case. As we get to the end of our time today, we will put the CLE accreditation number in the chat so you can take that with you when you go. And we are recording this, so it'll be available on our social media pages later today, so you can rewatch it and send it to your friends as you would like. So with that, I think what I'll do is have our panelists introduce themselves. I don't like to read bios, and so I'll have them talk a little bit about who they are and their background, and hopefully our other panelists will jump on as we're going through introductions. Oh, here's Erica now. Hi, Erica. We were just about to do some introductions, and I'm going to figure out where Miko is. I think she's in a waiting room in outer space somewhere. So we'll find her and get her going. But for now, Jean, do you want to start and introduce yourself?
Sure. Good afternoon, everybody. My name is Gene Commander. I practiced law in Colorado for over 3 decades. Started my career in a small firm in Iowa, and after 3 years came to Colorado. Was with Holland Evans for just shy of 20 years in the insurance defense world. Left that in 2000, moved into Shugart Thompson and Kilroy, which was a Kansas City-based firm with a Denver office. Did that in 2009. In 2009, Shugart merged with Polsinelli, and for a period of time there, we were Polsinelli Shugart, and then in my latter years, we were just Polsinelli. I was the managing shareholder in the Denver office from 2011 to 2015. Since then, I've been doing arbitration and mediation, so I've been in law firms and dealing with attorneys and learning about their businesses from that perspective for the last 10 years. And since the pandemic, I've been giving strategic planning business advice to law firms on smart growth strategies, and certainly billing and revenue generation is important from that standpoint.
All right.
Thanks, Jean. Yeah,
Let me
Doug,
go
ahead.
next. I'll just go next. So, hi, everybody. I'm Doug Tuminello, and thank you for joining us today. I'm a litigation partner with a firm that's relatively new to Colorado in its current iteration called Womble Bond Dickinson. But I've been at this firm and one of its legacy or constituent firms for the past 29 years. So I came here as a summer associate back when we were a much smaller firm and called Rothgerber, Apple, Powers, and Johnson. And then we've grown up ever since then. So now, as we stand here today, we have about 1,100 lawyers in the US and internationally, primarily in the UK. And I am the litigation practice group co-leader of our litigators. And so we have about roughly 300 litigators who are in my particular practice group. And I myself practice in the area of what we call complex litigation. And as I explain that to people, it means any type of litigation that no one else knows what to do with and comes across the transom. I and my other litigators say, yeah, we can do that. And so I've been with the firm for my whole career.
Thanks, Doug. Appreciate you being here. Erica, do you want to go next?
Hi, everybody. My name is Erica Gebhardt. I have been practicing law for about 14 years now. I'm managing partner at a mid-sized family law firm. I started a solo practice in 2016 when I had my first kiddo and wanted a little bit more flexibility. And then partnered up with a few other women, and now are about, I think, 15 family law attorneys. And yeah, that's what I do. So, and I also do child expert work, but that's not as relevant as, to today's
It
presentation.
could be. It could be. We'll see if we get there. Thanks, Erica. And Miko has landed from Zoom Outer Space. So glad you're here, Miko. If you want to
Sorry,
introduce
I was on
yourself.
a Microsoft Teams link.
Oh, yeah.
Don't know. Anyway, I worked for a tech company. You'd think I'd be better with tech. So hi, everyone. I'm Miko Brown. I'm a 2001 law grad and was a trial partner at both Wheeler, Trigg O'Donnell, and Davis Graham. And then after spending 19 years in private practice, I moved in-house to Airbnb, where I was Associate General Counsel of Trust and Safety. And I was at Airbnb for almost 4 years and then decided to gift myself a 1-year sabbatical for my birthday to spend time with my 3 kiddos before they up and leave, one for college. And then my middle son is actually leaving for boarding school in Calgary. He's a big hockey player. He leaves in August. So I've enjoyed getting to spend this time with them before I go back to the grind.
Great. Thank you, Miko. Thank you, everyone, for being here. I think this will be a great conversation. Before we jump into our first topic area, I want to let folks know if you have questions along the way, please feel free to use the chat or the Q&A function. We'll take them as we go, but we should have some time for questions at the end. So I hope you will definitely tap into this wealth of knowledge that we have with us. So let's jump into our first topic area, which is really revenue generation and billing structures. And because law firms are a business, we have to understand how they generate revenue. And so, Doug, I'm going to pick on you first. Would you walk us through a little bit about how your organization generates revenue from the services that you provide and what billing models you use and why you choose to use those?
Yeah, and thanks. I will. And as a precursor to that, I just want to reiterate the point you just made, which is law firms are a business. And often attorneys, particularly newer attorneys, don't necessarily appreciate what that means. But what it means at the end of the day is we want to generate revenue, which results in a profit. So we're paying all our bills and paying partners compensation and all our lawyers compensation. And if we do that, then we're successful. But we're a traditional firm, I suppose, in the sense that we still primarily use the billable hour or the hourly rate. It's sort of our base revenue generating technique. But we really look at every new matter that comes in the door separately and determine what the best billing structure is for that particular matter. So we'll use a variety of billing techniques. So in addition to just the standard hourly rate, we'll do contingency work, plaintiff's contingency work in the right cases. Typically for us, that would mean some type of business contingency case. But we'll also do flat fee work. We'll do retainer work, including retainers with collars. So some more complicated billing structures. So it really depends on the matter. Now, we're fortunate. We have a pricing team who helps us to figure out really what the best price and what the best price structure ought to be for matters. But really the ultimate goal is to, number one, drive profitability or drive revenue to the firm, but to do it in a way that's fair to the client and reasonable and justifiable in the approach. And what that means most importantly is that it's done with full disclosure and transparency for the client. So they understand what we're doing, why we're doing it, and how we're doing it, and they can understand the value that's obtained.
That's helpful. And Erica, I'm wondering, as someone who's in a smaller firm, but just as responsible for creating the billing structures, how do you approach that billing structure? And how does that then impact the way that you approach a particular matter?
Sure. So people, generally lawyers don't get into family law to be, to make the most money. It's definitely not the most profitable law field that you can get into. So at our firm, profitability is not actually probably our primary goal. I started my own firm so that I could take more flexible cases and really had a heart for access to justice. So the way that our firm does things, we take sustaining retainers from clients at a lower rate than most family law firms usually take, $10,000 retainer is usually the minimum. We take, between 2,500 and, sometimes we do have to take a $10,000 retainer or, even more because there's a trial coming up and it's a complex case. But generally we try to keep our retainers at a level that the average person, because, contrary to everybody else that I think is on this call, we're dealing with, everyday people that have never had, really probably not ever had a legal case before, and don't a lot of times have significant access to funds or excess funds. They're trying to take one household and split it into two. So cost is a huge factor for a lot of people. So we try to keep retainers low so that we can, give that access to justice. We do a free consultation so that if somebody can't afford an attorney at all, they at least can be pointed in the right direction to the JDF forms or, maybe some alternative services. We also offer unbundled legal services, which is basically where you don't enter your appearance on the case and don't show up to court, but you can give the client like behind the scenes kind of advice and look papers over for them and say, yeah, I think this is a fair deal. And then there was also a new, it was a Supreme Court wanted family law to have more access to justice and have more cost-effective representation, because there's so many family law litigants that are pro se in the Denver metro area court systems, which is a huge burden on the court systems in general. It's hard to deal with them. They oftentimes have to see them multiple times when it should just take one hearing because they don't know what they're doing and what have you. So they started basically paralegals can get a limited licensure. They have to take like a mini bar, and then they can practice law to a certain extent. They can't question witnesses. There's certain cases that are a little bit more complicated with a business interest or a trust case, and they can represent those people and show up to court with them and things like that. So our structures are really a variety of ways, and they're all, meant to be. We started very much in an access to justice mindset. We grew very quickly. And, despite that, had, pretty good profit margins from the beginning. So I don't personally take cases that are low level very often anymore, but we basically have, new associates. Well, you have the paraprofessionals that are the limited legal professionals all the way down to like 180 an hour. And then, it goes up from there from an experience level. And then in family law, generally your compensation is pretty tied directly to the number of hours you bill. Just like the big firms, we have a minimum hourly requirement. I think big firms usually have around like 180, I think is usually the expectation. Ours is between 100 and 120. But if you, want to make more money, generally the way that family law firms pay out and the way that ours does is you get a base salary, but you also take home more. So if you bill more and collect more, you're compensated more. So it lets associates, we are really seeing in this new, the most recent generation of lawyers that are, graduating from law school, that they really do care a lot about work-life balance. So some people really, feel really comfortable with the 100 to 120 hours, and, family law ends up being a good fit. So that's how we do
Yeah, I
things.
mean, a lot more flexibility, it sounds like, in a smaller scenario. But again, coming back to the value that you bring to the organization and your own values and what you're looking for can make a difference in how you approach, where you work and how much you work. Doug, there's a question in the chat about a retainer and a column, or with a collar, and I wonder if you want to just touch on that.
Yeah, Jonathan, thanks for that question. For those who can't see it, the question is, what is a retainer with a collar? So imagine a scenario where you charge a monthly retainer, and let's just say it's, I don't know, $20,000 a month to do whatever work needs to be done for this particular client. You still actually record your time, so you know the work that you're doing. And so let's say that you actually, and so the collar is intended to capture those scenarios where you do a lot more work than that $20,000 is worth, or a lot less work than the $20,000 is worth, to make sure that either the firm or the client aren't being treated unfairly. So let's say the retainer is $20,000 a month, and the collar might be $2,000 on each side. So if you actually work $22,000 worth of work in that particular month, more than that, then the client may pay you more, would pay you more under your retainer model. Whereas if you bill less than $18,000 in that particular month, you would then give a client a discount, if that makes sense. So it builds a fairness component into the retainer is what it does. And many people might think to themselves, oh, well, it's rather than billing in 6-minute increments, I'd rather just be able to charge a retainer and give myself that administrative ease, not having to charge or record that time. It actually doesn't work that way, unfortunately. You still have to record your time so you know what it is you're doing. And so you can explain to the client what it is you're doing on their behalf. So does that make sense, Jonathan, what the collar concept is?
Yeah, I think you explained it really well, Doug. Thank you. Miko, yeah, go ahead.
Good. No, I was gonna just wanted to follow up something Erica said, but if you've got a different question.
Nope, go for it.
So, and I think this is really an important point, and it was something that completely baffled me when I was an associate, and I was so happy once I learned this bit of information. But Erica said that compensation is largely is correlated to how many hours you bill, to your billable hours, which is 100% correct. But the little nuance that I finally learned when I was a senior associate is it's not just how many hours you bill, it's also your realization rate and how profitable you are as an associate. So for instance, when I was an associate at one of my firms, I would bill 1,800 hours per year, and this is a hypothetical, but I would bill 1,800 hours a year, and Jennifer would bill 1,800 hours a year. Based on that, you would think we would get paid the same amount, right? Because we both billed 1,800 hours a year. However, Jennifer is a lot more efficient than I am. So when she bills her time, that 1,800 hours that she billed, the partner who's reviewing our work and our bills before they actually go out, Jennifer was able to capture 90%. The partner only had to write off 10% of her time for inefficiencies, right? So she generated more revenue because more of that 1,800 hours was actually paid and sent to the client, and the client paid the bill. If I'm less efficient, if the partner has to write off 50% of my time, then it doesn't matter that I billed 1,800 hours. The client was only sent 900 hours worth of time and only paid 900 hours worth of bills. So that was really key for me because it really put the emphasis on efficiency. If you really want to maximize your compensation and how valuable you are to the firm and to the client, you really want to focus on efficiency. You want to be capturing as much of that 1,800 hours as possible. So it's really important to have a discussion with the partner. I would start asking the partners, hey, could I review the bills? I would like to know how much of my time you wrote off before you actually sent that bill to the client, because I want to get, a lot of firms have targets. They want you to be 90% of your time has to be able to be sent to the client. And they call that the realization rate. So that was a huge piece of advice that I got, and it really changed the way that I practice, where I started focusing a lot more on efficiency and a little less on billable hours.
Well, and actually sorry to play off her a little bit, but actually, so for us, it's even big firms tend to collect at a pretty high rate. Their clients pay them. Family law is not so much like that. And so actually, when you start as a family law associate, you actually kind of are running your own mini business. When we don't pay at all off of billable hours. Certainly, if you see somebody that, we do quarterly like discretionary bonuses. So let's say I brought in a case, they weren't going to be able to pay. I asked the associate to work on a temporary orders hearing with me, and they weren't going to pay till the permanent orders hearing 9 months later. I might give like a quarterly bonus because they billed all these hours that they didn't collect from, but we bonus directly from collections. And so part of having a smaller sustaining retainer means you need to be, if you see that the client didn't sustain, and sustain just means if they get $1,000, they put $2,500 down for a retainer, they get $1,000 bill, their credit card is charged $1,000 after the review cycle. So my associates actually have to keep an eye on making sure that the cases, if I case, I'll be responsible for the collections and pay attention to that client. But we teach associates from a very early stage to not only the realization rate, but actually the collectible rate, and you're kind of running your own mini business. I also did commercial litigation for a couple of years earlier in my career, and I thought actually what was even more helpful than reviewing the bills. Well, reviewing the bills, I force my associates to review them every time first of all, drafting bills is a skill. I frequently testify in reasonableness of attorney's fees at hearings on behalf of other firms. So when you've been to one of those hearings, you understand why bills need to look a certain way. But also, what I learned is you don't want to you don't even want to do if you should be spending 2 hours on a project and you spend 20 and you didn't know that, that's 18 hours gone that you can never get back. So when you walk into a partner's office and they give you an assignment, a good thing to ask as well as, questions about the assignment is how much time do you think I should be spending on this? Like when I get to this point, and if I haven't come up with an answer, maybe I'm looking in the wrong direction kind of thing. And so that I frequently ask partners that. And I always tell my associates to ask me that. I had an associate take 17 hours to make a spreadsheet that my paralegal could have made in 35 minutes. And, poor girl spent her whole Sunday evening doing that. And I was like, well, yeah, you shouldn't have done that. So that was just a practice pointer as well.
Thanks, Erica. And I want to get Jean into this conversation because I think what Miko and what Erica are saying are so important for especially newer lawyers or associates to understand is that they may not be profitable for their organization for a long time. And so how can, newer folks sort of position themselves, leverage themselves, see their value or contribute, even though they may not be profitable in their first couple of years at that organization?
I'll take that one. I'll just put a finer point on some of the things that have been said. To Miko's point, an early career attorney should focus on mastering the craft of being an efficient and effective lawyer, so that efficiency and the contribution to the realization is strong and as strong as it can be. So it's all about continuing to learn and refine your skills. In terms of the billable hour, a lot of the research I've done on the business of law since the pandemic indicates that in our market, the upper end on the billable hour requirements typically falls in the 150 to 165 hour a month range, which translates into the 1,500 to 1,800, 1,900 hours a year range. That's the upper end of what I'm experiencing, what I'm seeing. Doug, Miko might have a different perspective on that from their viewpoint, but just to put that in context. Thomson Reuters Institute tracks billable time and billable data across the country. And actually, the productivity of lawyers across the country has been dropping steadily for the past several years. And I think the average in all firms, in all states, in all sizes, is about 132, 133 hours a month. So there's quite a bit of discrepancy. So you can make some of that up with hourly rate. We'll talk about rates later, but you can't make it all up with hourly rate. The thing Thomson Reuters will emphasize is that the most profitability of a law firm is lost in the realization rate. Miko touched on one point, but realization starts with what's your standard hourly rate times a billable hour. If you discount that rate to get the work, you've discounted your realization. If you write down time, your time or an associate's time, you're discounting your realization. If you write off or discount the bill after you've sent it out, you're writing down that realization. And at the end of the day, to be profitable, the realization rate needs to be in the 90s. If it's in the 80s or below, you're going to struggle. That is where more profit is lost in law firms across the country. And so that really puts an emphasis on efficiency and continuing to learn and grow in your profession.
Thanks, Jean. I'm going to keep us moving into the idea of partner compensation, because I know for a lot of newer folks, that's a big, black box and no one really understands how that gets set. And we've talked sort of a little bit around it, but mostly from the associate perspective. So let's talk about partners. And Erica, I'll start with you because I know we're going to lose you here in a few minutes. But can you talk a little bit more in detail about your partner compensation model at your firm? And then I'm curious, Doug, as well, from your perspective.
So again, I think just going to be a very different answer from a smaller firm standpoint. We have 3 equity partners and then a junior partner at our firm. The way that we structure it, so I'm the managing partner and do about twice the amount of management than the other 2 partners do. They focus a lot more on their litigation, so they're arguably able to bill more, or take less time away from their billing with management responsibilities. So basically what we do is we doubled my salary so that that could be compensated, and then we split profits so basically, you know, we get a base salary, then we figure out the profits for the month from the firm, or on a, I guess, we do twice a month, but and then look at what, you know, what the profits were. And then we include the salaries as part of our expenses, and then we split in proportion to what we each billed that month. Because all three of us are similar aged. I have 3 kids. My other partner has 2 and the other partner has 1. And so, you know, sometimes, you know, I'll decide to take, I don't take trials during the summer generally, because I like to hang out with my kids and go on vacation and what have you. So summers tend to be a little bit lower billable wise. And if my partners are going to trial, you know, 2 times a week, they obviously should be compensated more for that. So that's how we do it. And our junior partner just gets, she's paid similarly to the associates, but she just gets a higher base and a far higher, she almost gets paid. Basically, we just take out her expenses, generally that, you know, office space, malpractice insurance, phones, stuff like that, that we could kind of individualize to her, and we take that percentage out of her profits and she gets the rest, kind of thing. And then, you know, of counsel then is lesser salary, lesser percentage, and then senior associate and then junior associate. So that's how we run it.
Doug, how do things work in big law?
Yeah, so not surprisingly, big law firms have different methods for determining partner compensation. You know, generally speaking, there are what I'd call black box models and open models. So in a black box model, one partner may not know what another partner is making or what the other partner's metrics are. They only know what their compensation is. We use an open model, so the partners know what every partner's metric is and how much compensation they're being paid. And there actually are pluses and minuses to both systems. You may have heard the saying that comparison is the thief of joy. Well, that's why black box models exist, because if you don't have any information to compare, then everyone theoretically is happy with what they make. But in any event, we use an open system because we find that in our firm helps to drive collaboration between partners, and it helps to the construction of teams in servicing clients and bringing up new lawyers through the ranks. So the way a partner's compensation is determined is really impacted by 2 factors. Number one is that partner's originations or business generations. So how much work comes into the door, whoever it's performed by, because of that partner's efforts. So that's the first component. And then the second is the partner's own collections, their own working collections, how much they're getting paid for the work that they do. And those 2 numbers then make up that partner's book of business, if you will. And so we're a merit-based system in that the larger your overall book of business, then the more you'll be compensated for the work that you do. But we incentivize our partners to develop their teams, to build their teams by sharing some of that credit. So if you're doing a case for a client and someone else is instrumental in working that case or maybe bringing it in or what have you, then we'll share origination credit for those other people. And that really helps younger lawyers too, as they kind of start to develop their business development skills. We take those figures and then we look at them really on a 3-year basis, a 3-year average. And then we have a committee that meets annually then to set compensation for the following year.
Thanks, Doug. And Miko, I don't know if you wanted to talk a little bit about the in-house perspective on, you know, how compensation works from, you know, for in-house positions and how that differs from private practice.
Sure, I can absolutely do that. If it's okay, I just want to piggyback one more time on what Erica and what Doug said. And this again was sort of an eye-opening moment for me when I was an associate. But I think most law firms have 2 potential types of partners. There's income partner and there's equity partner. Income partners are partners, they're W2 employees. They have a set salary, you know, bonus potential, just like associates do. they're paid a certain amount and you know how much it's going to be, and and it doesn't really matter how well the business does that particular year because your salary is set, just like an associate. If you are an equity partner, that means you actually are an owner of the firm. You're a part owner of the firm. And so you get, usually it's called a monthly draw. So you know a paycheck is going to come in every month, and generally speaking, what that amount is going to be. But then at the end of the year, after all of the bills have been paid, all of the staff has been paid, all associates have been paid, any money that is left over then gets generated and distributed to the equity partners. And so I think that's an important distinction to understand. And, and I tell associates when they're thinking about firms, that's something to consider. Do you want to go to firms where there's only equity partners? Do you want to go to a firm where there's both income and equity? And maybe you can start as an income and then build your way up to equity, because generally speaking, that's more profitable. You'll get paid more than an income partner at the end of the day because you get sort of the leftover of the business after everyone has been paid.
And oh, sorry.
No. So I just wanted to, because people I didn't understand the difference between an equity and an income partner until pretty late in the game. And again, that just sort of changes your way of thinking and your strategizing when it comes to your career, that I think is helpful to know.
Just an anecdote on that, I'd say, Miko, is when I was a young equity partner at a firm, and my distribution for that period was $1. So that's how much I got paid, because we hadn't brought the money in the door. We hadn't collected like we should have in the prior 2 weeks. That really crystallized the difference.
Yeah.
And crystallized the need for collections.
And I would just piggyback off that, as a smaller business, and again, we've only been in business since 2018. Certainly, equity partners probably in like a year basis do make more than a non-equity partner or a counselor, what have you. But there are some, we've had to take a case to trial where we had 3 partners on the case because it was a huge one, and they were the non-moneyed spouse, and so they didn't get access to funds till the end, and we had to do a trial with 3 attorneys, and none of the partners got paid for a little bit. And so and in those months, you actually probably do have the of counsel and the senior associates that are taking home a good portion and kind of know what they're doing and are pretty efficient at billing and what have you. They may take more home than a partner in a month, because with our district, like we're insured a paycheck, but if we can't cover that paycheck, we're not going to like go near the line in terms of, in our operating account and savings account. So if we don't, we have a number that we require that pursuant our operating agreement stay in the savings account, and then an amount stays in the operating account. And if we don't hit that and we can't pay our salaries, you owe money back. So, there are, in smaller firms that aren't nearly as established as these other 3 people have amazing careers at really, really well-established, well-known law firms. When you're at a smaller, firm like ours that is more specialized and what have you, it's a lot more. Our junior partner is not still a junior partner because she necessarily, we would probably offer her equity partnership, but she just had a baby, and she's like, I don't, if there's volatility at any point in profits, I don't want that. I don't want to be responsible for that right now. So it's really something to consider. And another note on that, we actually didn't have a partner track up until a couple years ago. And what we were finding is people would get to the senior associate level, and we could never get people to stay beyond, we required 2 years to even qualify for senior associate, 4 years to qualify for of counsel at our firm. We couldn't get people to stay that long because there was no way to become a partner. And so again, whether you're strategizing as how to be a new associate, or some people start law firms right out of law school and or have aspirations to start law firms, these are all kind of things to be considered when you're kind of looking for what you want to do, because there's definitely positives and negatives. And like I said, I worked for a commercial litigation firm, and it's just very, very different. They're completely, comparing apples to oranges kind of thing in terms of numbers and what have you. So,
Jean, I wonder if you want to talk a little bit about how the partner compensation model impacts the way that partners will work with younger lawyers, whether it's through mentoring or work sharing or supervision. But how does the model kind of impact those relationships?
I'd like to address that, but I'll put a finer point on just a couple things. I like to talk in terms of cash receipts because that's what comes in the door, regardless of the billing model. And that's what drives the engine. And the cash receipts fall into the two categories, usually for partner compensation purposes that Doug alluded to. There's an origination credit that identifies the total cash receipts that are attributable to the efforts of an attorney or a group of attorneys to bring cash in the door. And then there's the cash receipts that are attributable to the individual efforts of the lawyers in terms of their hourly rate and their billable time and how much and what the realization rate is on the combination of that billable time and hourly rate. So that I hope that's helpful just from a background standpoint. And then in terms of where it goes next and what it means, I like to say that the partner compensation system says a lot or sets the tone for many of the cultural aspects of the firm. And in Doug's example, if the attorneys are grouped into tiers so that there are a number of lawyers on the same tier and they're treated the same, that's one thing. If every partner is individually ranked and subject to an elaborate formula, that puts more incentive to worry about your own numbers than it does to be collaborative, as he mentioned, and work within teams and work within your tiers. For a firm that is the phrase is eat what you kill, where it's very formulaic and it's heavily driven on your own personal efforts, with more emphasis on your personal cash receipts rather than your origination cash receipts. There's disincentive to share your time with other activities. I don't like to talk about non-billable time. I like to talk about investment time. It's time you spend making the business stronger and making yourself a better attorney that doesn't translate into immediate cash receipts. But if you don't spend investment time on your business and on your practice, it's going to hamper your ability to create cash receipts in the future. So it's kind of do I invest in the short term or I invest in the long term? And so the different ways these partner compensation systems are implemented will either be an incentive to collaborate and share and to grow as a sort of the rising tide lifts all boats, or if it's more individualized, more siloed, it'll put less incentive for people to follow those things. And obviously, I was never in a system that was a black box. Various systems were more transparent than others, but I'm a believer in transparency. And but I think it's important for young attorneys to understand the firm's methods. They may change over time, but it's important because and for people looking for a new job or transferring to another place, I think it's important to have an understanding. Partners might be guarded to the extent that they share that information with people who aren't yet in the firm, but I think that having an open and honest conversation about that's important early in the relationship. Otherwise, it's just a transaction, and the profession has become much more transactional in the employer-employee context during the lifespan of my career than it certainly was years ago.
And I guess I have a question for you, Big Log folks. So at a smaller law firm like ours, we've had associates come to us and say, I will give up my guarantee if I don't like, if I can work from home or something like that, like, or like if I can take home a higher percentage, but without a guarantee. Our firm certainly will, again, we have different attorneys have different assets. My husband actually works for me. The guy never is there between that. He's never there from 9 to 5. He loves drafting pleadings from 10 p.m. to 4 a.m. He's, not my style. I can't be awake past 10. So, we certainly, if somebody comes to us and is wanting to negotiate different, kind of parameters and expectations in the office and we will discuss that. I don't know if big firms, if that is something that you guys do or not.
So we do, in the sense that we have individual deals with individual lawyers. And so we have we have partners, we have of counsel, associates, and we have a variety of those categories. And so if someone wants to have some form of alternate work arrangement, then we'll negotiate that individually, and it'll be more on an employment basis. They may not be an equity partner, but they'd be an of counsel or a counsel, and we structure it that way. With respect to our equity partners, for the most part, they're expected to be full-time equity partners.
I'm going to move us on to our next section, which is around business development, because in order to bring revenue into the organization, we have to have clients to serve. And I think a lot of folks think about business development as something for the partners to focus on, but truly it's a long game for every person in the organization. And so, Miko, I'll start with you on this one. I mean, what are some strategies that you've seen be the most effective for developing business? And how can newer lawyers, newer practitioners really support these efforts early in their career to start building their book of business?
Yeah, so I hope everyone gets to learn from the mistakes I made as an associate. But a myth, and this is something that I heard and I still hear being told to associates all the time, is just focus on your work, focus on becoming a really good lawyer, focus on your billable hours. That is true. If you're not a good lawyer, you're never going to develop business because you can't do the work well. However, I think it is a huge disservice when associates are being told, don't worry about business development. That's not something you have to worry about until you're a partner. And particularly when I think you're at larger firms, but even at smaller firms, the reality is no one is going to give you a case. No client is going to give you a case until you are skilled enough to handle it. And when you're a first year or second year, you're not. So it intuitively makes sense. I thought, okay, I'm not going to worry about developing business until I'm a partner or a senior associate and actually qualified for somebody to give me the work, because what's the point? Well, the point is business development is nothing other than relationship building. That's all it is. It has this mystique, networking, business development. It is relationship building. And the reality is clients are not going to give you a case, generally speaking, unless they know you, like you, and trust you. And it takes time to develop that type of a relationship where a client is going to feel comfortable enough with you to give you the work. And so I think there's a lot of merit to starting to build those relationships when you're an associate. First day out of the gate at your firm, start building those relationships, because it's going to take years to build that level of trust and comfort. And if it takes 5 years, well, guess what? In 5 years, now when you're qualified to actually do the work and handle the matter, you already have that relationship in place. I made the mistake of not starting to develop those relationships until I was a partner. And it takes, like I said, it takes time. And so it took me 3 years essentially of trying to build those relationships, build that trust before I was finally able to get work, even though I was qualified enough to do it. And so that's why I wish I would have started building those relationships when I was a young associate. So by the time I was qualified, those relationships are in place, that trust is in place. And now I'm poised, first day that I'm a partner, to start handling those matters.
Well, and again, so different areas of law. Totally. Again, we're not comparing apples to apples here. So, our associates actually take, like we call them baby cases. There might be an estate that just has a house, a 401k, no kids, but they want an attorney because they want to make sure it's done right. An associate can probably, like, we have associates that haven't even been practicing a year that, the way that our firm is structured is that we put a partner, an associate, a senior and a junior paralegal on every case to make sure that it's supervised. But generally on like the baby cases, I don't even enter my time, even if we talk about the strategy or what have you. I'll put in my time, but I discount it completely because, again, in our area of law, we can't bill $100,000 on every case. Like, you just can't. And when I worked in commercial litigation, I was like, oh my gosh, we're like only at the discovery phase, and we've spent 200 grand. Like, it was crazy to me because I had worked in family law before. So for when you're talking about like client development, I have associates that have been practicing very short periods of time, but can retain a client. I mean, I had one associate that she retained at like a 90% rate straight out of the gate. Like, we did a couple ICs together and she was doing trials with me and she started taking ICs and retained all of them. She was just very good at it. Now, that didn't mean that wasn't a network building thing though. At our firm, we have such a volume of cases coming in that I feed myself, and then I feed 5 other associates too. So I only take personal referral cases, and then my personal referrals still they usually feed 5 other junior associates on each of those cases. but we also just have general firm referrals, like from our marketing efforts. We don't make any we don't spend any money on marketing. We do like super lawyers and best lawyers. Once we qualify, we advertise in the magazine, but we don't spend any money on SEO or anything like that. You know, we sponsor, like my kids go to private school, so we sponsor their golf tournament and get, you know, some divorces from people, you know, oh, we got, you know, a pen with in the goodie bag at the golf tournament, like, you know, what was that law firm kind of thing. But, you know, in family law, you can start networking and bringing in your own cases very early. I mean, everybody, you know, people start getting divorced at 19. You know, I think the youngest divorce I did was 17. So, you know, in that area, you know, going to not even just law events, general networking events and things like that around town is super helpful. One of my partners was in the CWBA, so she had a lot of friends that were other types of attorneys, and they sent us a bunch of cases right out, you know, starting in 2018. So again, very different ways that we get clients versus a big firm. But yeah, we like our associates, where it was surprising to me because when I went to commercial litigation after practicing 3 years, I had been to trial 300 times, you know, like you go to trial in a family law profession 2 to 3 times a week when you're an associate. And so, especially if you have a big caseload, and I always did. And so when I went to commercial litigation and they wouldn't let me take a deposition, I was like, what do you mean I can't take a deposition? Like, or, you know, what do you mean I can't take a witness? And so it's, again, very, very different. And, you know, skill building is very, very different. And so, I mean, some divorces are very, very complicated and you need a super high level of skill and to know how to issue spot and what have you, but some cases are pretty easy and associates can handle them. So again, how you become successful in your own realm in family law is going to be very different. So.
Thanks, Erica. And Doug, I mean, I think Miko and Erica did a good job at sort of talking about the client acquisition portion of this, but then there's the client retention. And I know with the work that Erica does, you don't really, you know, keep clients long term. I hope they're not getting multiple divorces, but I guess that's possible. But I think, you know, in other areas of practice, you want to retain those clients over years and have work, you know, continually coming through. So can you talk a little bit about that retention process and kind of what goes into keeping clients around?
Yeah, that's a great point. I think to me, it comes down to customer service, client service. It comes down to the client experience. And so, let's assume that we're all doing great work, because I know we all are. We're all doing great work for our clients. So then the differentiator has to be something else. And often that something else is what the client experiences when they come to your firm. And so it's, you know, the number one client complaint is responsiveness. So, and that's such an easy thing to address, being very, very responsive. But then the clients are looking for other things too. They're looking for strategic guidance, for example. So a lawyer who's just not being reactive to a problem, but's helping to forecast the road ahead for a client, what's happening in the industry or in legislation or in the economy that may be of importance. And so that they like to see their firm reach out to them proactively to say, hey, this is what we see coming down the road, just as a heads up. So there are things like that. Client communication is such a big thing. And one of the biggest, most consistent ways in which we communicate with our clients is through our invoices, our monthly bills. So ensuring that those bills really demonstrate value and the value add through the time entries and through the descriptions of what you're doing. I think that's really important. It's something that's often overlooked by lawyers. But it's just like you want to feel whenever you go to a restaurant or you go, to anywhere, or when you hire your own service providers, you want to feel special and treated right. Our clients, your clients feel the same way.
Can I piggyback onto something that Doug said? And it goes to the realization rate, as well. And that is with billing. And I think this is so critical for associates to understand. And I wish more firms would actually train associates how to bill, how to record their time, because I see in both in-house and when I was at a firm, when I was a partner reviewing associate bills, it would say, attention to emails, 1 hour, review documents, 5 hours. And as the partner, I've got to write off a lot of that time because my client is not going to be happy reviewing that bill. And so what I would tell my associates is put yourself in the shoes of of the client if they're getting the bill. When they read the bill and they see 5 hours reviewing documents, are they going to understand what you did, why you did it, and are they going to feel good about paying it? And if the answer is no, then you need to add more detail to your bill. If it is, 5 hours reviewing documents for potential pitfalls in our defense, and key information that we need to send to our experts. If I'm the client, I feel when I read that, I understand why it took 5 hours to do that document review. I feel good about paying for it because I understand how it moved the ball forward. And if I'm the partner who's reviewing the associate's bill, I feel good about sending that bill to the client. If I get, I can't even imagine how many hours I wrote off from associate time because I said, there's no stinking way I can send this to the client. When it says, 1 hour reviewing emails, 1 hour on conference call, it doesn't work. So I think one of the best things that associates can do is put yourself in the client's shoes and think, if I'm reviewing this bill, am I going to feel good about paying this based on my description? And if the answer is no, beef it up.
I think that's such an important point and sort of leads to the next question I had as we sort of wrap up here, which is how can firms and organizations support associates and new lawyers in understanding this? Because I feel like when I started practice, no one sat me down and said, here's how you construct a bill so that the clients see the value in what you're doing. I had to learn that the hard way as well. And so what else can we be doing to help people understand the business of law and what goes into value? And Jean, just if I don't know if you want to start with that, just since I think that's sort of your wheelhouse.
And the climate for business development is changing as clients' needs and attitudes change. It used to be that we felt like if we did good work and we had good relationships, that we would, the easiest way to get new business was from existing clients. There's a really fascinating article by the Harvard Business Review from fall of 2023, where they really drill down into what are the different things that rainmakers do that are successful. And one of their observations was, based on their studies, pre-pandemic, 76% of clients said they would go back to the firm that they had worked with before. By 2023, that had dropped down to 53%, and it's projected to be down to 37% by 2028. And what that tells us is that the soft professional services that lawyers and accountants and public relations and recruiters used to be protected. They used to be protected by the executives and the leaders in the company. They're now getting scrutinized by the bean counters, just the way all the other expenses are. And so we're being as an industry, we're being held to greater scrutiny. Another thing is that not all lawyers are good marketers. Not all lawyers are good at and successful at business development. Not all lawyers enjoy it. We're not trained. We don't come from those backgrounds. And I think one of the historic pitfalls, shortcomings of many law firms is that because the partners have never been trained, they don't know how to train the junior people. And so, and that gets back to the double hour pressure and the realization pressure, and my concept of cash receipts, and my concept of investment time. If you aren't willing to invest your time in business development, and if you aren't willing to invest your time teaching others how to be successful at business development, you're going to limit the cash receipts that are earned short-term and long-term by the firm. And so, again, that takes you to what is the culture of the firm as it relates to professional development for junior people. And that takes me back to, what is the compensation model? Are there incentives or disincentives to provide that investment time to fulfill those professional development goals? It's a real delicate balance, and it varies and necessarily should vary from firm to firm to be successful.
Apologize to everybody. I had to hop out a quick status conference. That was actually
You had to go bill some time. We understand.
So.
Point two.
Getting in your billables.
I was gonna say, yeah, there's a point too. But what I would say too, and what I would just note, like, again, so what's really interesting, again, because family law is, I think, again, it's kind of so beginning of your career focus, like you can, you can become a pretty well, I mean, I was pretty well known in the family law community. It's small. By the time I was a third, fourth year attorney, because I started doing expert work, and there's just not a lot of people that do child expert work, and I have a niche market. And so then everybody was using me as their child expert, and then just got a lot of referrals that way. But the interesting thing is right now, 2025, attorneys that graduated in 2020 are now 5-year attorneys, but really, haven't, they grew up, so to speak, in the COVID world. And what we are seeing, the real, marketing you kind of do of yourself in the family law world is really just it's just talking to people. I mean, becoming not like, again, it's really good to hone in on something that is your like niche. So people are like, oh, she knows a lot about retirement, military retirement, or, she knows a lot about LGBTQ children issues, or, things that are like, she's a domestic violence expert. So that is a way, like becoming more knowledgeable in and of itself makes you well known, and you kind of, that markets you, just markets you very easily. But what we are having kind of a hard time with associates, and I don't know how much the big firms are seeing this, but when I was an associate and a partner would invite me to or even just a mentor, an older attorney or a more experienced attorney would invite me to, a family law section, happy hour or something like that. I mean, I would never turn it down, right? And we have a hard time getting, I'm on like 4 or 5 boards, and like we're having a hard time, if there's a CLE and then a happy hour, people show up for the CLE on Zoom and don't show up to the happy hour and what have you. And what I'm really trying to, I'm really trying to encourage with our associates, like, I know you haven't experienced this yet, but meeting people face to face, giving them a handshake, yes, you can be knowledgeable in a certain area, and that's great. But if they know you personally, and like in family law, your word is everything, being truthful, being professional, being kind, being empathetic. Right. I just had to go to the status conference, and I had to have emergency surgery last week. And so they had to push back the conference because I'm the hearing, because I'm the expert on the case. And, again, one attorney's being mean to me, and one attorney's like knows me and is being very, very empathetic. I mean, when you have those kind of relationships, you don't even have, I mean, you don't have to pay for marketing. You don't have to really do anything extra. You just have to show up. So I'm just really trying to encourage our young associates that, again, started, finished law school in the virtual world and started their careers in the virtual world, to like show up in person. And we're doing this over Zoom. So I'm saying show up in person, and we're doing this over Zoom. Every board I'm on, I am like, let's not make a Zoom option. If people want the CLE credit, show up in person so that I can meet you face to face and form a relationship with you, because that's what, there's one of the boards is between attorneys and mental health professionals. And, I'm like, I want to know the mental health professionals. I want to, get their viewpoint on different issues while we're having a cocktail, so that's
Well,
just.
thanks. Yeah, no, I agree. And we used to have these in person and nobody showed up. So that's why we put it on the webinar. But I agree with you. I think showing up, and I want to thank all of our panelists for showing up today and taking time out of their billable schedule to do this. I've put the CLE number in the chat. It's 858-536. If you want to take that with you, and you can claim your credit for today. We will have this recording up on our social media channels later this afternoon, and we're taking August off. We hope you will too, and come back in September. September 18th, we'll be back with COLAP, who will be providing a presentation on barriers to well-being and causes of impairment in the profession. And so thank you again to Jean, to Doug, to Miko, to Erica for being here, and we'll see you in the fall. Thanks, everybody. Yeah.
Take care.
Thanks, everyone.
If anybody does want to talk or anything like that, Ryan, you have my permission to pass along my, contact information with my firm, because I'd be happy to have, again, I love meeting people in person. So if you have any further questions or want to discuss kind of where you want to take your career, certainly hit me up.
Thanks, Erica. Everyone knows they'll be in touch. All
Thank
right.
you.
Take care, everybody.
Take care.
Bye-bye.
Bye-bye.